And welcome once again to the Employment Law Show. Good to have you along for the ride. My name is John Scholes, and beside me, of course, employment lawyer Lior Samfiru from Samfiru Tumarkin, stlawyers.ca. Before we even get started over the next half hour, I want to remind you that you can reach out anytime to Lior and his amazing team. The phone call might be your first step. Always ready for a chat. 1-855-821-5900. Email address we will use going forward and any other time is help@employmentlawyer.ca. And the website, which you're going to hear about it in just a bit. It's really handy. It's free. It's anonymous. It was put together, created by Lior a few years ago to make you smarter, give you all kinds of knowledge about your workplace life and employment laws. It's real simple to use, free, anonymous, called pocketemploymentlawyer.ca. And you'll have access as well to the severance calculator, which will be on full display here momentarily as we get into some calculations, and we'll show you exactly how that works. As well, the main topic, fast facts about independent contractors. Are you one? Are you not? We will clear all of that up a little later on in the show. But, Lior, we always start off, pal, with the case of the day or week that was. What do you say?
Hey, John, great to be here, of course. Great to be talking about employment law, such an important topic. And I can tell you over the past few weeks, I've been getting more and more calls, people that have been let go, people that have significant changes to the terms of their employment. Maybe it's economic times, maybe it's the sign of what to come. There's lots of talk about a recession. So the reality is, in these uncertain times, you may have issues that come up to your job. Your job may not be as secure as you think it is. I can't do anything about the security of your job, but what I can make sure is that you have your rights, you know your rights, and that those rights are enforced if something happens to that job of yours. You have significant rights when it comes to severance, compensation if you lose your job. It's a lot more than you realize, probably a lot more than what your employer thinks or wants to pay you. But it doesn't matter what the employer wants. What matters is what the law says. So on this show, on every show, we talk about those rights and many other employment rights, of course. If you're being mistreated by your boss, if your job has changed, if you're given an ultimatum, you're told to resign, you name it, we touch on these topics. So this is where you learn about this very, very important and very vital topic, employment law. To get us started, of course, always want to talk about a situation that came across my desk. As a reminder, you can reach out to me, of course, in the office if you're facing anything that you want to discuss. So I spoke with a gentleman who found out that his job was being changed significantly. He was in a very senior role, and he was told now he has to take a lesser role. He wasn't happy about it. But his boss told him, listen, I need you to be a team player. This is it. We're going to put you in that new role, and that's going to be it. So do this for us. Do this for the team. Take this little demotion, and that's going to be it. From now on, things will be fine. So he decided at the time to take his employer word for it. And even though he didn't have to accept that demotion, I'll talk about that in a second, he decided to accept it, to be the team player, taking his employer word that that's going to be the case. Well, what happened is several months later, company says, listen, it's not working out. We have to go through a restructuring. We're going to put you in a much very different role, not a managerial role at all, a sales role. We're going to change your compensation structure to a commission structure, and that's going to be the new reality. So then he contacts me. The problem with that, John, I think you know where I'm going to go with this, is because he allowed the company to make that initial change, he's now given them the right to do it again and again. Now, his employer did not have a right to make that initial change, that initial demotion. That could have been a constructive dismissal. Your employer doesn't have a right to just demote you. You can treat that as a constructive dismissal and leave with severance. But if you don't do that, if you accept the change and continue working, by doing that, you've given the company the right to do something similar again and again and again. And when they do that, you won't be able to do anything about it because you let it happen the first time. So I had to tell this gentleman the bad news that because he opened that door with that first demotion, he is now stuck and he can't do anything about it. Terrible news. I hate giving news like that. But this is such an important reminder that if your job changes, your compensation changes, your hours change, if you don't want it to happen again and again, you have an opportunity right away to deal with that as a constructive dismissal, but you have to act quickly. So if you change, or if you're facing a change to the terms of your employment, you have to reach out to me right away.
What were his options? We often discuss that, Lior, is other than saying, no, I'm just not going to accept it. If he really likes the workplace, maybe the boss and his colleagues at this point are super good friends. You know how that works. Can he say, you know, I'll give it a try for a bit, but I'm not committing wholeheartedly to this? Is that an option?
What I would have done here is to say, employer, I'm only accepting this because you've assured me that I'm not going to face other changes. So that's the deal that we have. I'm going to accept this. I'm not going to say you've done anything wrong, but you've assured me, and only because of that, I'm staying. You've assured me nothing else happens. At that point, once the employer did break the deal, then he'd be able to say, sorry, it's still a constructive dismissal. But because there was nothing like that in writing, it becomes his word against his employer's word. That's not possible. So if there's a deal in place, you have an agreement, you want the company to abide by it, you have to get something in writing. It could be an email, it could be something as simple as that, but it has to be in writing.
You know, a lot of our viewers may be thinking as well, Lior, it sounds like, they gave him a bit of a positional change, but they didn't mention a demotion in money. His earnings still see the same. So what's the big deal? Does that change the calculation at all?
Yeah, that demotion unfortunately did come with a change in compensation. Not a massive change, but a change in compensation, which he decided he can live with. The problem is when they did a second change, now with a bigger change in compensation, because he let it happen that first time, now he's stuck. So this is a real thing. When I say if you let your employer get away with it, you've opened the door to bad things, that's a real thing. That's what happened here. And for him now, if he does quit because of it, he's not going to be getting any compensation. So please don't let that happen to you.
Again, reaching out anytime to Lior to discuss these matters, 1-855-821-5900. Employmentlawyer.ca, great website. While you're there, the media page, not only this TV show, we air pretty much across the country, but Lior and I do a ton of radio all over the country as well. We get a lot of great phone calls coming to the radio shows. Most of them are an hour long as well. You can always tune in, find a station near you that broadcasts the show, and feel free to call in, be part of the show, ask your questions, because when you do that, you're actually asking questions that thousands of other people are scratching their head about too, generally, so feel free. We get some calls. Lior, as you know, we play them back here and we talk about them. Phone call number 1 for this show is coming up right now.
I'm a sales manager at a large hotel. The past week and a half, we heard that we'll be running as an independent hotel. There has been talk that if we do run as an independent hotel, there will be some layoffs. Like they'll give them a week pay for every year. Me being 50 years old, doing this for over 15 years in the same position, can they do that?
What do you think?
Great question. I get this often. I believe I'm going to lose my job. There's rumors, and there's also rumors that the company is only paying the minimum severance. Well, here's the thing I want everyone to remember. It's not up to the company to decide what they want to pay, how much they should pay. The law makes that determination. So your employer doesn't get to say, hey, we decided that we only want to pay you this much. Too bad. The law comes in and says, you're going to pay what you have to pay. So no, it does not matter that this person works for an employer that doesn't want to pay the full amount. This person is owed her full compensation. So I can tell you exactly how much severance she's owed, but I want to show you how you can find out for yourself how much you're owed. So I'm going to take her information and I'm going to go to our handy dandy tool, the severance calculator. You can, of course, find it at pocketemploymentlawyer.ca. And let's use that tool and let's see how much severance she actually gets. So we know she's in a sales role at that hotel. She's 50 years of age, been there for 15 years. The minimum may be little, maybe as little as 15 weeks. But the full compensation, the full severance that she's owed, we can see that as much as 18 months of severance. That's what she's owed, so that's what she's going to get. Now, that doesn't mean that her employer is not going to try to get away with paying her less than that. Employers often try. That's why you reach out to me and my team. We'll make sure that you get everything the law says you should have.
Let me take this one step further before we get to our second phone call, Lior. Say this new owner says, okay, we want to keep you on, you're a great employee, but here, sign this new employment contract. We know the problem with that, don't we?
Oh, yes. Listen, we'll talk about it more again even later, but generally speaking, anytime your employer wants you to sign a new employment agreement, doesn't matter what reason they give, anytime they want you to sign that, that is a bad idea. One of the things that are almost certain to try to get into that new employment agreement is a term that limits your future severance. So you may sign an agreement that has the effect of saying that instead of getting 2 years severance, you're going to get 8 weeks severance. And if you sign that agreement, you may then ultimately potentially be bound by it. So if your employer, whether you've been working there for a year or 20 years, whether there's a sale of a business or whatever the circumstances, if you've been asked to sign a new employment agreement, please don't sign it, not without me seeing it first.
Again, employmentlawyer.ca. Find a radio station close to your jurisdiction where you can tune into the show pretty much weekly. Phone call number 2. Lior, going to play it back right now. Listen up.
I've got an employment agreement that calls for a minimum number of weeks of termination pay. After they've informed me that I'm terminated, they're starting to make sounds like they're going to try to trump up a case, go after me for cause. Can an employer, once they've informed you that you're terminated, can they then, after the fact, can they kind of come up with some reason and we've changed our minds, we're going to try to terminate you for cause?
There you go.
So there's a couple of things to discuss here. The first thing is, he may have a contract of employment, as I was talking about sooner, that tries to limit his future severance. But one thing I want you to understand is that in many cases, I'm going to say 75% of cases where an employment agreement tries to limit severance entitlements, it doesn't do so effectively. There's various reasons, which I don't need to get into here, where an employment agreement may often not limit your entitlement. So you may have signed an employment agreement, and the company comes to you and says, well, based on that agreement, we only have to pay you this much. The reality is that may not be the case. You may still be owed your full severance. So even then, even more important than ever, you have to reach out to me. Now, with respect to the second issue, can your employer, after the fact, say that they have just cause to let you go? Listen, in some situations, after a company lets an employee go, they go into his mail or computer and they realize that he was doing something very, very bad. So if after the fact your employer learns that you were stealing from them, you were cheating them, you were committing fraud, sure, yes, they can do that. They can allege cause after the fact. We call it after acquired cause. But the employer has to prove that you did it. They can't just make up stuff. They can't just do that for no reason. So I wouldn't worry about it unless you know as an employee that you did something very, very bad. Otherwise, no, they can't do it.
We have a third phone call coming up on the other side of the break, which we're going to get into now. It's a short one, so stick around for that. And then we're going to get into all about being an independent contractor. That is on the way as well. Stick around. Lots more. The Employment Law Show is on the way. The phone number anytime as well to reach Lior and his team, 1-855-821-5900 and help@employmentlawyer.ca. We're coming right back. Stick around. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you. They may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back, Employment Law Show. I'm John Scholes. Joining me, of course, Lior Samfiru. To reach out to Lior and his team anytime. They always welcome your phone calls when we're not doing this half hour of the TV show or radio shows, for that matter. 1-855-821-5900 to reach out. help@employmentlawyer.ca. And that website built just to make you smarter. Use it anytime. It's anonymous. It's free, of course. pocketemploymentlawyer.ca. Okay, Lior, third phone call from one of our radio shows is coming up now. Let's listen and talk.
Well, today in my work, they told us that we're going to be shutting down our plant, and they're going to be moving us into another plant, which is just down the road, but it's a union shop, and right now we're not union. I've been there 25 years. I have straight days right now, and it's going to be going to continental shift. So I just wanted to know, do they have to offer me a severance package?
A lot going on there.
A lot going on. And listen, to be moved from a non-union position into a union position, that's a massive, massive difference. It changes the nature of the job completely. It's a 180. It really is. So whenever we're talking about a significant change to the terms of employment, we have to think constructive dismissal. We talked about that at the beginning of the show. When your employer makes a significant change to the terms of employment, you have to think constructive dismissal. That gives you the right potentially to consider your employment as being terminated and get severance. And this is despite the fact that the company is not actively letting you go. They didn't call you into a meeting and saying you're let go. You're the one that makes that decision. So again, in this situation, now being in a non-union position for 25 years, now you're going to be a unionized employee. Very, very big deal. So yes, he can consider that to be a constructive dismissal. Tell his employer, no, I am instead going to treat that as a dismissal, get my full severance. The question, of course, you know what that is. How much severance? What does he have to gain by doing that? We're going to go back to pocketemploymentlawyer.ca, use our severance calculator tool, and let's see how much severance is at stake for this gentleman. So supervisor role, been there for 25 years. Company's not offering severance because they're not letting go. It's a constructive dismissal. Except we see right there he's owed anywhere from 22 to 24 months of severance. So it's up to 2 years of severance. Again, despite the fact he was never let go. Company is wanting to him. Company wants him to continue working. But because of what the company did, putting him in a very different position, that's a constructive dismissal, which he does not have to accept, and he's owed as much as 2 years severance.
You know, it's interesting, Lior, because that unionized piece is interesting because a 25-year guy, had he carried over, got his union card, started working, and in a year from now gets let go, it wouldn't be 24 months under those union rules, would it?
It wouldn't be, no. And certainly one of the many things that happens when you become a unionized employee, you give up your severance rights, your full severance rights. The collective agreement has very different other entitlements, minimum entitlements. So if you're going to lose your job, certainly no one wants to lose a job, but if you're going to lose a job, you're far better losing your job as a non-union employee than as a union employee because you get a lot more severance.
Yeah, you played the right card here for sure, Lior. That's definite. Okay, fast facts about independent contractors. Let's dive right into this one. Employee law determines whether an individual is an employee or an independent contractor, not your employee. It's not their call.
So very important to remember is it does not matter. Couldn't care less what you think you are, what the company you work for says that you are, thinks that you are. It does not matter. The law, employment law, determines if you're an employee or an independent contractor. If you look like an employee, you're an employee. If you don't, then you're something else. But I want you to remember that just because you signed a piece of paper saying you're an independent contractor does not make you an independent contractor. Just because you're paying your taxes like an independent contractor or you're charging HST doesn't mean that you're an independent contractor. What matters is how you do your job. If you have regular hours at a company that you've been doing work for a while, the law's going to come in and say, you've gotten this all wrong. You are an employee and therefore have all the rights of an employee.
Fact number 2 is this: a misclassified employee typically works under the direction of a sole company and employer.
So an employee that's been misclassified as a contractor generally means that you're working for one company. You do the job that they tell you. You have a boss. They tell you what to do, where to go. Whereas a contractor, a true contractor, has a bunch of companies they work for. They're clients or customers. What's the example I always like to use? The plumber, right? If you have a problem with your leaky faucet, you're going to call your plumber. The plumber's going to come in, fix the leak, and then go to a different customer. And he's going to do that again and again every single day. He's not your employee because he just came in, did a job, and left. But if the plumber came to your house and only did work for you 8 hours a day, 5 days a week, guess what? That plumber would be your employee. So always ask yourself, are you like the plumber that has a bunch of customers, in which case you're a contractor, or are you really an employee? And if you are, doesn't matter what you call yourself.
We are talking about fast facts when it comes to independent contractors. Number 3 is this: Lior, misclassified employees miss out on vital employment rights. We're talking overtime pay, minimum wage, things like that, yeah?
There's a reason why we have employment laws, because we've decided that employees need to have these rights and protections, but those only apply to employees. They don't apply to contractors. So if you're really an employee, you should have all these rights. As John said, vacation pay, overtime, of course, severance when you lose your job. And you're not getting them because you've been misclassified. So you have to remember, if you're really an employee that's being called something else, you are giving up on an entire list of rights that you should be getting. That may be especially important if you lose your job. If you lose your job, the company may say that you don't get anything. I'm telling you, you're owed severance, and that could be a lot of compensation right there.
We'll get to one more fact here, Lior, when it comes to independent contractors. And just before I get to that, I want to remind you, if you're watching the show today, any other questions about this topic, again, over to pocketemploymentlawyer.ca. There's a section on independent contractors. Super handy, super easy to digest. So have a look at that as we get to our fourth one. Independent contractors are not owed compensation upon termination. However, many are, in fact, employees, and they are owed severance, right?
So I'll give you an example just from a situation that I'm dealing with as we speak. I have a client that's been working as a manager in a plaza for about 4 years now, and worked there full time exclusively for 4 years. But at all time was quote unquote an independent contract. He was invoicing the company once a month. They were paying the invoice, and they've been doing that for 4 years. He was just let go because the company decided to bring in another manager. So the owner of the plaza is saying, "Oh, you're an independent contractor. We don't owe you anything. Goodbye." Well, guess what? He is an employee. He's been misclassified. He's worked there exclusively full-time for 4 years. So of course he's an employee. Of course he's owed severance. For him, that's going to be easily 6 months severance, potentially even more than that. I'm going to help him get that. So that's how this works. The company you work for may say, "We're not owing you any severance because you're not an employee." If they've misclassified you, which they likely have, yes, you are owed severance, and you have to give me a call.
All right, we'll get into a short break here, Lior. When we come back, the website terminationquestions.com. That's available for you anytime. We're going to pull a question from that website, terminationquestions.com. So we'll do that on the other side. The phone number anytime as well, 1-855-821-5900. You're watching the Employment Law Show, and there's more to come. People think you have to sign back a severance offer by a deadline. Employmentlawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at employmentlawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. Employmentlawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at employmentlawyer.ca. All right, welcome back. Employment Law Show continues here, Lior. A few minutes to go. Let's get to it. Terminationquestions.com. That's where I'm getting this question from. So listen up. Says, I was diagnosed with a severe case of vertigo a few months ago and must use a walker. I've been working from home full-time the past several years, but shortly after my diagnosis, my employer requested we return to the office at least 3 days a week, something I'm not able to do right now. The HR department has reached out and suggested I'd be better on long-term disability. Can they force me to go on LTD when I'm still working from home? What do you think?
Your employer can absolutely never force you to go on disability. The only one that gets to decide if you go on disability is your doctor, no one else. Now, in this situation, this touches on the duty to accommodate. If this person has a medical condition that requires her to work from home, her employer must accommodate. We know that the employer is able to do it because she says she's already been working from home for several years. So the company can't say, oh gosh, this is just too difficult to do, when they've already been doing it and presumably have had no issues doing it. What she needs here is a simple doctor's note saying, this person for medical reasons cannot come into the office. They can and they need to continue working from home. Once the doctor says that, it really is over at that point. The employer can't question that, they can't deny it, they can't refuse it, and they can't tell the person to go off on a disability leave. They have to accommodate. If they refuse, that's a human rights violation. It's a very big deal. So same thing applies to you anytime you need some help and support from your employer. Modified duties, modified hours, working from home. If there's a medical reason for that and your doctor is putting that in writing, your employer has to make all efforts to provide that accommodation.
Want to make mention you can also join Lior and his team on their live streaming. That happens on YouTube and on Facebook. How do you find it? At ST Lawyers. At ST Lawyers to join that live stream. Ask a question like this one. Says, Lior, I've worked at a dental office for over 15 years without an employment contract. Last week I was told there was new documentation I had to sign. I refused as I'd never needed a contract before. Can they let me go if I refuse to sign?
So right at the beginning of the show, we were talking today about employment contracts, employment agreements. I'm using the term interchangeably, and that is if you're all of a sudden being asked to sign a new employment agreement, that's bad news. There's going to be, I can almost guarantee there's going to be terms in that agreement that are unfavorable to you, including something limiting your severance, maybe something that gives the company the right to change your job, to change your compensation, a non-solicitation, a non-compete. You name it, there's very problematic things that likely are included, and that's why your employer wants you to sign. So what happens? You can absolutely refuse to sign. Can they let you go because you refused? Yes. And the reason for that, an employer can let you go pretty much for any reason as long as severance is paid. So yes, your employer is going to have to pay you your full severance if they let you go because of it. But here's why that may be better. Because right now, if you haven't signed an employment agreement, the company wants to let you go, they can pay you your full severance. That could be as much as 2 years. But what happens if you sign the employment agreement that limits your severance and a year later they let you go? Then potentially they can only pay you a fraction of your severance. Maybe instead of 2 years, it's 2 months. So that's why if you're going to lose your job, you're better off not having signed an employment agreement. But bottom line is this, if you're asked to sign an employment agreement, let me see it. Let me read it. Let me tell you what it does and what it doesn't do. And you do that before you sign it.
All right, Lior, let's keep rolling. It's time for the Employment Law Show rapid fire questions. Here they come. Here we go. Number one, pal. Can employees be told to take on more responsibilities?
So generally speaking, the answer is yes, unless, of course, the effect of more responsibilities is that the nature of your job has changed significantly. Remember, your employer can't change your job in a significant way. So if by giving you more responsibilities, now you're doing a vastly different job, you can say no to that. They can't force you or discipline you for refusing.
All right, rapid fire question number two. Can employees be let go for cause due to theft or maybe fraud?
Yes, if you committed fraud, if you've stolen from your employer, you can absolutely be let go for cause. That means no severance is paid. But remember, the company has to prove it. You don't have to disprove cause. So if the company has the evidence to prove, they can let you go. If they don't, they can't, and they have to pay you your full severance.
Rapid fire question number three. Can employees report incidents of bullying and harassment at the workplace?
Absolutely. Not only can they should. In fact, they must report harassment and bullying in the workplace. The company has a legal obligation to deal with these, to investigate, to take it seriously, and to rectify the issue. But they can't do that unless they're aware of what's happening. So always report that to your boss, to HR, if you're being harassed or mistreated, and always in writing.
Okay, we're rocking. Number four. Can employees be forced to relocate to a distant branch or office? What do you think?
Anytime a relocation is distant more than an hour away, we have to think constructive dismissal. Usually that's something your employer cannot do. If you're in that situation, you give me a call.
Rapid fire question number five. Can employees return to work from medical leave with restrictions?
Absolutely. We touched on that. You can come back with restrictions, with modified duties, modified hours, as long as you have a doctor's note. Your company has to accommodate if your doctor says so.
Okay, last couple. Can employees be placed on probation at any point during their employment?
No. Probation really to have an effect has to be in the first 3 months of employment. Probation is not automatic. Only if your employment agreement says you are on probation, and only for the first 3 months. If you're put on probation, quote unquote, later on, it doesn't have an effect. It doesn't do anything. So if you lose your job then, you're still owed your severance.
Okay, pal, final one. Can employees still get severance pay if the employer's offer deadline expires?
That deadline is meaningless. Your legal rights don't expire in it. So yes, you have 2 years to pursue your entitlements.
There you go. You made it through, man. Go towel off. You're all good. And we're just about done as well. You want to reach out now that we're wrapping up for the half hour? Do so. Call Lior, 1-855-821-5900. Help at employmentlawyer.ca. That website again, pocketemploymentlawyer.ca for any other matters and the severance calculator as well. Thank you so much. We'll catch you next time on the Employment Law Show.